Liebe Kollegen,
dear members of SIPE, friends, ladies and gentlemen, this is a great pleasure and to meet you all on the occasion of the 11th SIPE Congress. We were in Göttingen, Seville, Strasbourg, Lisbon, and Athens after the founding Congress in the island of Crete. This time, we hold this event in Bucharest, a town which was mentioned in 1859 as a city at the crossroads of the trade roads and also the capital of Romania. According to the founding legend, this town was founded by a shepherd, Bucur. As in Romanian, Bucur also means bucuria, that is joy, many Romanian writers spoke of Bucharest as the city of joy. That is why it is such a pleasure to celebrate the 7th edition of the Young Researchers Workshop that was first held in 2008. We tried to pick a very topical issue this year, something that will bring together a lot of legal experts from different states and from different legal backgrounds. That is to say that we will speak about European conventions and we will consider their dimensions. Migration is maybe the most important issue to tackle for the future of Europe. In my opinion, it is more important than the financial crisis or the Brexit. The various wars from the areas outside Europe do force people from there to leave their country and to leave their own culture as well. Besides that, to these people we add economic migrants. So that creates, because of the size, a new challenge for Europe, for state sovereignty and the welfare state. To what extent the current legal framework can face or can cope with this wave of migration is something to discuss here with famous experts for the next 2 days. According to our tradition, the speakers as well as the participants to the Young Researchers Workshop come from various countries in order to make a contribution to this conference. So we included on our agenda many topics, and we tried to reach a balance between German, English, and French, the 3 official languages.
which explores different aspects of the main topic and could thus bring fresh ideas. I am very grateful to you, our speakers, who have accepted the challenging task to deal with very complicated issues, and also to the local organizer of this Congress, Professor Elena Simina Tanasescu, who gave us the opportunity to discuss such an important topic in the wonderful city of Bucharest. Meine Damen und Herren, ladies and gentlemen.
Ladies and gentlemen, we would like to thank you all for your contributions, and we hope this will be a fruitful and dynamic event. And on behalf of my friends from the panel, I would like to wish you all and all of us complete success in this conference, and why not to try to spend together some pleasant hours in the city of Bucharest, so rich of tradition.
Some more relaxed time in the traditional and culturally rich city of Bucharest. Au nom aussi de mes collègues du comité exécutif de la SIPE, je souhaite
În numele colegilor, on behalf of my colleagues from the Executive Committee, I would like to wish you success. In the city of Bucharest.
Merci, chère présidente.
Thank you, Chair. I'm not Vasco Pereira da Silva, because Vasco comes from Lisbon and he will arrive very late this evening. So I will replace him and chair this meeting. There will be 3 speakers: Christoph Betzemek, Michal Jakovsky, and Cardinal Brumar, and myself, Jacques Ziller, who will read Ms. Roberta Smongiano's paper, who couldn't come, but she sent us a summary of her paper. The idea is, first of all, to listen to 3 papers. And then we will read the presentation of Ms. Roberta Mungiano, and we will open the floor to discussions. There will be simultaneous interpretation. And for that, I would like to thank Ms. Semina Tănăsescu, who thus gave us the opportunity to meet here and to communicate. If you have problems with any of the 3 languages, there will be simultaneous interpretation. And now allow me to give the floor to Mr. Christoph Betzemek, Associate Professor from the Faculty of Economics in Vienna, who will speak to us about migration from the point of view of the state theory. You have the floor, Professor Betzemek. Thank you, Chair. Allow me to thank you for giving me the opportunity to speak today about migration from the perspective of the state theory. Migration is a word that can be interpreted in several ways depending on the context. That is why perhaps from the very beginning we should see what the scope of this notion is. Ladies and gentlemen, a migrant is a person found on a journey. This word, however, does not describe completely the meaning. A migrant is not just a traveler. He is an immigrant. He is an alien looking for shelter, for refuge, who wants to get integrated into a certain community, in a certain place. The difference is obvious, as Georg Siemens said in his research about socialization. Practically speaking, this journey means to become separated from a point in space. It is a sociological phase of the alien, or the feeling of being alien. It's not somebody who comes today and leaves tomorrow. We are speaking about a person who comes today and stays tomorrow. So this potential traveler will be a migrant who will stay. Not any traveler will be a migrant. The starting point lays in the difference between the individual and the group, and the experience of the alien as a social phenomenon. An alien is the one who comes today and leaves tomorrow. That is the question. This is the phenomenon of the presence. This is the experience of otherhood, the otherhood who has just arrived. But he is not just an upstart. He is not like any other. To be an alien is not just some otherness. It does not mean the presence of the other. To be an alien qualifies the difference. There is a difference, a salient difference, which is obvious. a difference that is manifest in the features, and the features of this individual do not belong to the community. That means that closeness can be far, but to be an alien, it means to bring this otherness very close. So there is a dialectics between close and far. That creates an external orientation point in this respect. So there will be a group identity, and there will be a difference in the quality of the alien, meaning that, for instance, the language will be the element around which the community will be formed. The alien, he tries to find a spiritual link, and he begins to separate from his own native community. And that creates a difference between the natives and the alien population. The language, which will be the core means of communication, will be in the same time a moment of social distinction. That is why communication as interaction in order to promote understanding, communication as interaction with a view to understanding what is familiar and what is alien, what is the difference between the two. And that is a paradox. But historically speaking, we have seen that the barbarian, meant in Greek language an alien, somebody who would stammer, who would use some strange phrases, barbar. Please excuse me. We do have a communication problem here, which does not make any of us barbarian. Don't worry about that. So, the integration of the alien in a certain group, something that is required, politically speaking, more and more often, is something obvious on this backdrop. So, we have the eye of the community on the alien, and the idea that this alien should be integrated. This eye of this community is very important from the point of view of the state theory. But an unintegrated alien does not mean it's less important, because from this perspective, we see this distinction between being far and being close. And this is how a remarkable characteristic comes to life. And the alien becomes core to the state theory. This alien, as Iman said, does not hold the univocal trends of the group, but it comes with a specific and objective attitude. This doesn't mean that this will not mean impartiality or reserve. There will be a mix of closeness and remoteness. In the same time, an alien, a person who is involved but is not affected, can correspond to the central demand of Rousseau, the superior spirit that looks over the passion of the human beings but can't feel any, can't experience any. An individual that, however, is aware of the fact that our happiness depends on everything and tries to consider all these topics. This inattentive attention of the alien allows him or her to be more objective. The alien's objectiveness is ipso ensured without any other constructions being necessary. In this point of view, We don't need the gods to bring laws to people, as Rousseau said. An alien is a person also who acts in order to promote his or her own interest. That is why the alien can become useful in the theory of the state. It is not just an eidetic experiment. That is why the objectiveness of the alien can be used and can be integrated in the legal framework. This is an option in itself. Rousseau gives even an example in this respect. Most of the Greek cities, the polis, made the following thing. They entrusted their law not to the people inside the polis, but to people outside the polis, to aliens, therefore. Such examples are very clear. However, the Old Testament about Moses running away the Exodus from Egypt is quite significant for this phenomenon. Sigmund Freud tells us that Moses is the redeemer and the promoter of Israel, but he was not a Jewish himself. He was Egyptian in Freud's theory. According to Freud, Moses was a person speaking a different language and someone who could not communicate with the Jews without an interpreter. So that means that there was a difference of language between the two, Moses and the group of the Jews, and that is important. The question whether Moses was Hebrew or not is not so important, but the symbolism behind it is important, as well as the consequences. Namely, that at the foot of Sinai, the people of Israel was led by a foreigner, by an alien, who gave these people the laws, the 10 Commandments. So we have a social and a normative dimension there. The constitutive power will be different from the constituted power. And that creates a dichotomy. This shows us a certain order between what is ordered and what is subject to order. The lawmaker is an alien that comes today, stays tomorrow, but also only to promote laws and then to move forward. Irrespective whether this enactor lives further by himself or he's determined to do it. However, Moses makes this decision before the Jews reached the Promised Land. Another example comes from a character who would rather starve outside Sparta in order to give more authority to the legal framework that he created. The enactor will be separated symbolically from those who are regulated by the rules. The ruler cannot in the same time be the law enactor, because otherwise the laws will be just tools of his passion and his injustice. On the other hand, this will not become apparent in the sacrality, in the sacred character of his work. If a alien stays too long in a community, starts losing from its objectiveness. An alien is a person who comes today and stays tomorrow, as we said, irrespective how short this tomorrow is. But he will become subjective in time. However, this does not mean that we see an overnight change into a native. We see the alien changing into a native overnight. But in time, the alien will be subordinated to a legal order in the place where he comes. As we read in the Bible, in the Exodus, an alien is a guest. He can be a guest and a host in the same time. The alien is different by the very fact that he is alien. He's tolerated in a state, but this doesn't mean he is deprived of his rights, because tolerance is something like a quasi-legal framework or foundation, at least from the point of view of the state treaties. From this perspective, we don't test the exactness of the alien's image. This brings us to state institutions, early state institutions, kind of proto-states or primeval states. As we also see in chapter 17 in Leviathan, we can read there about community protection, or the protection of the community in front of the alien invaders. Of course, not all alien invaders are potential enemies, but as John Rawls pointed out, the idea is that the rights given by the state to the alien are deemed true privileges. This means that the alien will be object to the provisions of the law. And in the same time, the final result of the inclusion will be a condition of its exclusion, as it happens in the Spartan city, where aliens were expelled from the city. In the 20th century, this is something considered barbarian. What an interesting semantic choice, but it is acceptable in point of state law. Starting with the end of the 18th century, when we start to see the theory going around the inalienable rights of people, we are no longer faced with this phenomenon of the exile, of the expulsion. But this is also the dawn of a new era. It is the moment when the first states, national states, were formed. And this is the starting point in expressing a starting point at the beginning of a nation as we have it today. In Article 3 of the Declaration, a nation is defined. And I speak too fast, I'm sorry. So, nation is defined in the Declaration on Human Rights, is at the core of all sovereignty principle. So, the rights that are present in the Declaration of Human Rights are interconditioned. But it is not the same for the legal position of the individual. So the rights were simply some abstract notion then. These rights represent the foundation of nations. And as Lefebvre wrote, these rights have both an inclusive and an exclusive potential. We are dealing with a nation which is very fragmented, but which is grouped in an association of citizens. This fragmentation inside a unitary state, formally speaking, will set limits towards the outside. Citizens are opposite to the aliens, aliens who are not citizens of that state. And that brings us to the issue of sovereignty. which excludes the aliens from the right to citizenships. According to Maas, this is the foundation of the national state as a concept. And inclusion, on the one hand, needs the criteria of blood and land, and on the other hand, citizenship, which is acquired according to some prerequisites that are established by each community, will include, among other things, mastering of the national language. I won't dwell more on that. Once the alien is integrated, we must consider the following. The alien, through his integration, will no longer be an alien, will be like dissolved inside the recipient community. That means that somehow he will be or she will be included in the nation and will be no longer an alien. That will create just a formal border between inside and outside, and citizenship will stand proof to belonging to a group. That moment, citizens, no matter who they are, will be holders of unalienable rights. On this backdrop, and leaving aside similar constructs of citizenship, an alien, according to Hannah Arendt, will only hold an abstract quality of being human, a right to have rights. Rights with regard to the community. Based on this right to have rights, the alien can be received and can seek reception, and once morally speaking, to be included. And this will call for decoupling the right from belonging to a certain space and the emancipation of the individual locus classicus will be translated in the claims of the alien. The request for hospitality, the request for a peaceful existence, which is part of the civil law. And this is not just mere philanthropy, mere charity. It's not just mere hospitality towards a guest who arrives on the land of a community. It also means that we should not show a hostile feeling to the alien. It is the right of the alien to visit a certain place, and that belongs to all human beings that will be integrated in one society or another. What is remarkable in this concept of the right of migration, it's a council semantic choice. Hospitality brings us immediately to the idea of hospice. In Latin, it means also guest and host. So you can be an alien and both a native in the same time. The roots of these concepts go back in time. In Latin, the host is hospice, coming from the same root as enemy, hostes. And that creates a relationship whereby the alien is placed somewhere an enemy and a friend. So that creates a certain uncertain status, which was something also mentioned by Thomas Hobbes. Hospitality, therefore, ends where hospice, the guest, proves to be hostes, meaning hostile, an enemy. The moderator keeps telling me to slow down but he also motions to me to keep with the time that was allotted, which means that I should skip a few paragraphs. I'm sorry. It is remarkable how far in our practice of the rule of law and in our theory we've come. Kant mentioned that as the right of the universal citizens. However innovative Kant was, we are far from that point. The right to hospitality based on the standard international standards of protection no longer mean what this used to mean in the times of Kant. We are speaking about hospitality as a legal obligation. It is mandatory. But this does not mean the right to an asylum. But refoulement creates some relational field that we'll hear more about from Professor Jankowski. It means to create a certain relationship with those who are excluded and receive people who cannot lead their lives somewhere else in a way that promotes their harmonious development. This also means the ability to host a person who is a guest for now, ignoring whether this person will later become hostile, meaning an enemy, hospes. Such an alien who, based on the right of universal citizenship, acts and does several things, is a guest among alien. This is the question. The right to hospitality means to be an alien among aliens, which means also a fundamental claim to be a human among other human beings. And this creates the difference between the quality of being an alien, which is sanctioned by the norm. The geopolitical landscape is now marked by nationalism and nationalities. But we can also speak on a narrow front about the fact that a citizen can retreat behind the individual and becomes emancipated. This emancipation points to a concrete order of the law, even if recognition and the obligatory character lies with the law and the state. That also points to the right, the universal right of the citizens, which means that an alien is an alien among aliens. An alien must be an alien. This is not a status, it is a starting point. Individuals in their diversity are not alien one to the other. Then the inalienable character of their legal position turns the inalienable character into otherness. So mankind, and I will conclude on that, mankind has taken a step further towards what Kant imagined to be the constitution of the universal citizen. We will try to see to what extent this is still possible. And I'm very happy to listen to the further discussions that will be triggered by my paper. Ladies and gentlemen, thank you for your attention, and in the same time, I apologize if I spoke too fast and too slow in the same time. German is a language which is tailored for law and for legal thinking, but in the same time, it is very difficult to be translated. That is why it is important to speak slow and fast in the same time.
Norberta Mungiano, which I will read later on, and I'll immediately give the floor to Michal Jakowski, who is assistant professor in the University of Poznan, and who will talk about the conventional rights of refugees and asylum seekers. The floor is yours. Yes, put it on. Yes.
Hello? Oh. Okay. Ladies and gentlemen, dear colleagues, guests, thank you for being here. The subject of this paper is particularly important for me. Poland is a country affected by the problem of migration, but in one specific way. Regarding refugees, for a few decades we've been a sending country, not a receiving one. Situation when Poland was a host country for refugees are either very distant, for example, large migration of Jews in the 14th century, or politically motivated and strictly limited. Meanwhile, the migration from Poland was incomparably greater. Huge waves of political refugees accompanied falls of each of the Polish uprisings in the 19th and 20th century, the economic crisis of late 20s, the Second World War, the 1968 anti-Semitic campaign provoked by communist authorities, 1980s martial law, and also accession to European Union. So for these reasons there are very loud demands in Poland to take care of Poles living abroad, their descendants, their families. There are programs to collaborate with Poles living abroad, to mobilize Poles abroad to actively participate in the social, cultural and political life. Even seeking justification for existence of the Senate was assigned a function of the chamber that protects Poles living abroad. The paradox, however, is that despite these experiences, we cannot see the rights of refugees. The Constitution proclaims the right of asylum, but it is the only one that is not protected by constitutional complaint in Poland. The content of the provision of the Constitution refers to the statute. This is why there is no judgment of Polish Constitutional Court concerning this issue. In addition, Poland is one of the, as you know, Poland is one of the countries which opposes the solidarity mechanism of, let's say, distribution of refugees. Also recently, an atmosphere of fear of strangers, of aliens has arisen, fueled by forces which until recently were completely political marriage. On the other hand, Poland is still a country very sensitive to human rights. The Constitution strongly exposes in the preamble that there is no return to the bitter experiences of the times when fundamental freedoms and human rights were violated, which is the communist period, of course, and the Charter of Fundamental Rights covers a very significant part of the Constitution. Courts have applied the Constitution and the European Convention on Human Rights directly for over 20 years, and you can find thousands of judgments based on the case law of European Court of Human Rights. Therefore, it's so crucial to present a standard convention related to the protection of refugees. And when I was invited to this conference, this was my first idea, to present how the standard, the case law have developed. However, the entry into force, the agreement between the European Union and Turkey in 2016 tempted me to assess how these standards are applied. Firstly, some general remarks. The European Convention on Human Rights was an act adopted in order to defend citizens and not any human beings against arbitrariness by the state. This refers a bit to the first lecture of Professor Bezemek. It was not considered to protect the rights of migrants. For these reasons, for many years, the migrants' applications have not been found with merit and declared inadmissible. Analysis of the case law of Strasbourg Court leads to the conclusion that it overcomes barriers associated with such the interpretation of the Convention, but in very small steps and in very specific areas. European Convention contains only two provisions regarding migrants. The first provision is Article 5, paragraph 1.f, providing rules of the lawful arrest or detention of a person when it's required to prevent his effecting an unauthorized entry into the country, or of a person against whom action is being taken with a view to deportation or extradition. The second one is the alien clause, is Article 16 of the Convention, which provides that nothing in Articles 10, 11, and 14 shall be regarded as preventing the contracting parties from imposing restrictions on the political activity of aliens. This provision reveals the idea of the Convention, that the alien is a human being who does not and should not have the same rights as a citizen. Calls for the abolition of this article have been expressed since the late 1970s, and the article has almost never been relied upon by the European Court of Human Rights to restrict the rights of aliens. I found just one judgment in case Piermont versus France of 1995 that refers to it. Notwithstanding, the clause reveals the spirit of the Convention. This is why, despite the first notorious migration problems of 1960s and 70s, it was 1985 when European Court of Human Rights rendered very first judgment in a migrant case. This was comparatively late. By then, the court had already been active for over 25 years and issued a number of important decisions creating general human rights doctrine. This first case, Abdulaziz Cabales and Balkandari versus United Kingdom, it's called ABC versus UK, was decided on May 28, 1985. It should be beyond the scope of this paper because it's not related to the rights of refugees and asylum seekers. The applicants were immigration widows, women living in the UK for many years without their husbands because immigration rules prevented the husbands from joining them. This judgment must be mentioned because the court emphasized that a matter of well-established international law and subject to its treaty obligations, a state has the right to control the entry of non-nationals into its territory. And the duty imposed by Article 8 cannot be considered as extending to a general obligation on the part of contracting state to respect the choice by married couples of the country of their matrimonial residence and to accept the non-national spouses for settlement in that country. This view is typical for courts thinking of migrant rights, and it was repeated by the court in a number of decisions. One may find different views, for example, Judgment Sen versus Netherlands of 2001, or Tukabo Tekle versus Netherlands of 2005, but they regard extreme cases concerning family reunion demanded by very young children or even infants. The view that stipulated in Abdulaziz ABC versus UK was repeated, confirmed in one of the latest judgments, Biao versus Denmark. The second case worth mentioning is Berehab versus Netherlands of June 1988, and it was the first one concerning the expulsion and the first case in which the court held that the removal of an alien from the territory of the country is a breach of Article 8 of the Convention. It's worth also mentioning, however, that before this judgment was rendered, 90 previous complaints, very similar complaints regarding the expulsion, were deemed inadmissible. The earliest came in 1959, indicating how long Strasbourg system works before the judgment on Berehab was delivered. This case also does not directly concern the subject of this paper, as refers to issue of second-generation migrants. However, it's worth mentioning because in the reasoning part of judgment on violation of Article 8 by deportation of such persons, the court has not adopted or not accepted the principle that long-settled migrants should, for the purpose of considering deportation, be treated like a national and thus not be considered deportable. Contrary, outcomes depended in all these judgments concerning deportation, outcomes depended on the balancing performed by Strasbourg Court case by case, taking into account first 8 and later on 10 established criteria when determining whether deportation violates the Convention. Since 1996, there have been numerous verdicts of non-violation in such the cases, and that allowed to consider the case law on this matter as a lottery. It should be noted that in a recent judgment given by the Grand Chamber in case Uner versus the Netherlands in 2006, the court reaffirmed that states are entitled as a matter of international law and subject to treaty obligations to control the entry of aliens into its territory and their residence there. The Convention does not guarantee the right of an alien to enter or to reside in a particular country, and contracting states have the power to expel an alien. After these general remarks, let's go to conventional provisions protecting migrants. First one is Article 3, cases under Article 3. The first case was Suring versus UK, the case of 3rd June 1988, when the court acknowledged that the obligation under Article 3 of European Convention prohibits sending a person to a place where it can be subjected to torture or inhuman or degrading treatment or punishment. The ruling was immediately adopted in matters concerning failed asylum seekers and recognized refugees, preventing them from deportation to a place where they might be at risk of encountering conditions prescribed by Article 3. It's found to be one of the leading cases of European Court of Human Rights and remains a founding authority. In case of Cruz Varas versus Sweden of 1991, the above-mentioned view taken in Suring case was extended to persons who are not granted asylum. Also, failed asylum seekers shall be protected under the Article 3. Over the years, however, it was disputed who is responsible for demonstrating the applicability of inhuman treatment against the applicant. In case Cruz Varas, Strasbourg court sided with the state, considering the applicant's explanations as doubtful and no immediate trust. The ruling is considered to be the first seed of tendency not to believe the complainant regarding the situation in which they find themselves, even when they have no real possibility of proving their allegations. Another tendency was an assessment of the possible violation of Article 3 ex nunc. It means the court assesses the reality of the risk of inhuman treatment at the time of its consideration of the case. This view was slightly changed later on in the Sadi versus UK judgment, and it was assumed that the burden of proof lies on the state side when the applicant's case is arguable. Finally, in the case Vilvaraja and others versus United Kingdom of 1991, the court stressed that in determining whether state responsibility is in fact engaged in a particular case, a balance is to be struck between the demands of general interest of the community and the requirements of the protection of individuals' fundamental rights. The consequences of finding a breach of Article 3 in the present case, it was a case of people from Sri Lanka, would be that all persons in similar situation facing random risk on account of civil turmoil in the state in which they lived would be entitled not to be removed, thereby permitting the entry of potentially very large class of people with the attendant serious social and economic consequences. In this judgment, the court said that this is the applicant who should demonstrate special distinguishing factors indicating why he or she would be at risk of ill treatment upon return. It was not easy then to claim for Article 3 protection. Another important view was taken in several subsequent judgments when court assumed that the prohibition of torture is absolute and cannot be abolished in connection with war on terror. Finally, the application of Article 3 was examined in the last two cases related to refugees' rights. The first case is Hirsi Jama, case of people taken by ship from Italy to Libya, expelled to Libya. The court observed that there are two different aspects of Article 3. First one is the risk that applicant would suffer inhuman treatment in the country of deportation, Libya, and the danger of being returned to their respective countries of origin. This was in the case Eritrea and Somalia. The court must examine the foreseeable consequences of the removal of an applicant to the receiving country in the light of general situation there as well as his personal circumstances. Third third observation was that information contained in reports from independent human rights protection association, like Amnesty International it was in this case, are very vital when assessing the situation. Article 3 may be applied also where the danger emanates from persons who are not public officials, when the risk is real and the state is not able to obviate the risk by providing appropriate protection. And when assessing if there is a violation of Article 3, the risk of return to country of origin, concerning the risk of return to country of origin, the court must observe both the legislature guaranteeing respect for fundamental rights and practices resorted to or tolerated by the authorities. And in case Claifea versus Italy, the court added that when examining a violation of Article 3, it has to take into account conditions of aliens' detention and their cumulative effects, including overcrowding, respect of privacy, ventilation, access to natural air and light, quality of hearing, basic hygiene requirements, and general situation resulting from organizational and logistical difficulties regarding exceptional waves of immigration, named even by the court as the state of emergency, must not be underestimated, but however cannot exempt the respondent state from its obligations to guarantee conditions that are compatible with respect for human dignity. Okay. Let's skip the. Okay, I was just told I have 4 minutes. Okay. It was noted that in the Cruz Varas case, the court found a violation of Article 3, but also it was put in the question whether the violation, expulsion, violates of the refugees and refugees' families may violate Article 6 and Article 8. And in the judgment, Cruz Varas, and in many subsequent judgments, the court found that violation of Article 3 and the expulsion violating Article 3 is without prejudice to Article 8 of the Convention. Only in exceptional cases it accepted application of Article 8 of the Convention. And concerning Article 6, the court stressed that the decision of whether an alien should be able to stay in the country is a discretionary act of the public authority, which falls outside the scope of Article 6. This view was adopted by the court in several decisions, subsequent decisions, and is one of the highly awaited views to be changed. The doctrine of law stresses that Article 6 of the Convention should be applied pursuant to Article 47 of Charter of Fundamental Rights of European Union. Other provisions that may protect refugees and asylum seekers, it's Article 5. There are two leading cases concerning the immigration detention. First one is Shahal versus UK. Second one is Sadi versus United Kingdom. In these cases, the court discussed the meaning of the words detention of a person to prevent his effecting an authorized entry into the country as a reason to detain an immigrant. And the court repeated that immigration detention is not subject to a necessity test. It's the only provision of Article 5, the only exemption from Article 5 that doesn't need to be a subject of necessity test. However, this view was criticized by both Parliament Assembly of Council of Europe and Committee of Ministers, and this view was slightly changed in the recent judgments in Claifea versus Italy, when the court it was the first judgment when the court balanced interests and in fact referred to proportionality when assessing if the immigrant detention violates Article 5. And finally, Article 13 of the Convention that requires that asylum proceedings should be examined very under scrutiny. The leading case is the case MSS versus Belgium and Greece. What's worth mentioning, the European Court of Human Rights found the Belgium expelling migrant to Greece as a first country of asylum could not do it automatically. It should examine very thoroughly if the Greek asylum proceedings comply with the Article 13 of the Convention. And the court assessed that the Greek proceedings violated the prohibition of inhuman treatment. The last provision, I would skip a bit due to the time. The last provision that could protect the refugees is Article 4 of Protocol number 4. It prohibits collective expulsion of aliens. Collective expulsion, it was defined by European Court of Human Rights as any measure of the competent authority compelling aliens as a group to leave the country, except where the measure is taken after and on the basis of reasonable and objective examination. And there were two cases of concerning violation of this provision. First case was both were mentioned before. First case, Hirsi Jama versus Italy, when the group of Libyans were just taken by the ship to Libya directly without examining anything, without identifying anything. It was found that it's a pure violation of Article 4 of Protocol number 4. But more interesting is the second case, Klaifia versus Italy. The applicants were subjected to identification procedure, but the court found it insufficient because the court said that the expulsion was collective in fact. The refusal of entry orders didn't contain any reference to the personal situation of the applicants, and the government failed to produce any document capable of proving that individual interviews had taken place prior to issuance of the order. So also, expulsion may in fact violate Article 4 of Protocol number 4. This is the summary. You may see the summary. The refugees and asylum seekers may be protected by Article 3, prohibiting deportation, Article 13, requiring examining of violation of Article 3 under scrutiny, and Article 4 of Protocol number 4, prohibiting a collective expulsion and requiring assessment of individual situation of all the refugees. And in special circumstances may seek also protection in Article 8, especially when case concerns very young children, and Article 5, paragraph 1.f, under recent judgment, which requires equality of law expressing exemption of right of liberty. And complaints based on Article 6 until now should be found inadmissible, but the doctrine of law awaits a change of this view. Let's see how these standards are applied. Do I have some 5 minutes? 3 minutes, okay. How the standards are applied? As you all know, on March 18, 2016, the EU and Turkey have reached an agreement on refugee issues, which has aroused considerable legal and political controversy. The most controversial is point 1 of the statement, because it's the form of the statement, which states that all new irregular migrants crossing from Turkey into Greek islands as from 20th of March will be returned to Turkey. This sentence is an obvious breach of Article 4 of Protocol number 4. It contradicts a prohibition of collective expulsion. As it was mentioned before, the provision requires objective and reasonable examination of particular cases of each individual of alien of the group. As you may observe, the rest of the provision tries to change the intention of this provision. Firstly, it stresses that the measure is temporary. However, it's not explained how temporary it is and when its binding force ceases. It must be stressed that Article 3 that should be applied, must not be limited by any temporary measures, even in case of such the emergency as it was observed in Greece. Secondly, it's made clear that the EU Asylum Procedures Directive will apply to those who reach Greek islands. The text doesn't refer to Greek waters and Turkish waters. If people are automatically returned from Turkish waters, in my opinion, it would violate also European Convention on Human Rights as it was decided in Hirsi Jama case. As for migrants not applying for asylum, the crucial question is whether they will be given an effective opportunity to apply for asylum, as the Court of Human Rights case law requires. It must be noted that in MSS case that I just mentioned, it was decided that Greek asylum procedures violate Article 13 of the Convention, and there is no sign it has improved since. And if an application is unfounded, that means that it has been rejected on merits, and inadmissible that it has not been rejected on merits but on the grounds that Turkey is first country of asylum or safe third country, it is doubtful if it may be applied. Because firstly, Turkey was found in European Court case law as the greatest violator of Article 3 and 13. In return cases, it was not able to examine fundamental issues relating to the complainant's concerns and individual conditions. Secondly, treatment in Turkey will need to match EU rules in the Procedures Directive, which define a safe third country. It's doubtful if Turkey may do it, because Turkey does not apply the Geneva Convention to non-Europeans. There is also, of course, a view that it's sufficient that Turkey applies equivalent standards in practice, but both legislators, for example, statutes providing temporary rights for refugees, especially of Syrian origin, and practice show something different. In my opinion, this is why Turkey cannot be unquestionably found as a safe third country. And we can find out about some judgments of Greek authorities confirming it. My conclusions. The convention is not, however, the convention is not an act to protect aliens. There have been developed quite high conventional standards of refugees and asylum seekers protection. However, the EU-Turkey agreement violates these standards in so many ways that it must be considered as a bypass of the convention. The question should be put whether we should keep our standards in case law and bypass it in practice, or to decide to decrease the standards a bit. And the second question is whether the risk of ill treatment concerning the migration itself and the conditions of the flow of migrants waves justify limitation of conventional standards. I cannot find the answer. Maybe we can do it for next day during our conference, but we await a Grand Chamber judgment in the Klaifia case, and the Grand Chamber should answer whether such the high standards of Article 4 of Protocol number 4, for example, prohibiting a collective expulsion, should be applicable, should be still applicable. I think the answer is before us. Thank you.
Thank you very much.